Good morning, everyone. Welcome to WILMIC's summer seminar. I appreciate all of you coming. For those of you watching on the web, welcome to you as well. We're going to cover a lot of ground today. You saw the title, and it deals with client expectations. Those are changing, and so we're going to get into a whole myriad of things that relate to that. Confidentiality, communication with clients, attorney-client privilege, advertising, malpractice, claims prevention issues, social media, unbundled legal services, even bartering, legal Zoom, online services kind of stuff, and fee collections and billing, kind of the new normal, if you will, in the law practice. My name is Tom Watson. I'm with WILMIC. We will do the first panel for an hour and 15 minutes, then we'll take a break at 10:15. We'll reconvene at 10:30, and then we'll run close to noon. Feel free to ask questions at any time. You don't have to wait for the question and answer period. Feel free to interrupt. We'll get your questions out there. For those of you on the web, you will see a question box. It's in the lower right-hand side underneath your video box, and you can submit a question in there. We will get that, and we will entertain those questions as well. So feel free to shoot those out anytime. We have two really good panels today, and I want to get right to it. Our first panel consists of Ira Zaroff on my very far right. Ira runs the Oregon malpractice insurance company, although he has many Wisconsin ties. He graduated from UW as well as UW Law School. And then we have Jeff Smith. Jeff Smith is a solo practitioner in Madison. He does mostly patent law, and Jeff has some unique perspectives on handling clients, and so we'll hear about that. And then to my immediate right is Sally Anderson. Sally is Vice President of Claims at WILMIC, and so we'll hear her perspectives too. So let's get right to it. Ira, I'm going to start with you. You have been in this business for a long time, I think upwards of about 40 years. I imagine you're going to tell us that things aren't today quite what they were back when you started.
I'm going to. I'm going to my 40th year reunion this summer in Madison on September 20th. So I've been doing it a long time. And I think that when I'm thinking about the difference between when I started and now, the biggest difference really is consumerism, and it's social media and the pressures that social media brings on lawyers every day in their practice. When I started, and this didn't go on for a long time, there was a fee schedule for divorces which lawyers could not depart from. There was no competition, basically, in terms of pricing. The number of lawyers was much smaller. Lawyers were seen as elite professionals in many ways. They certainly were not subjected now to the same kinds of pressures that you all are. And it's just a very different thing. And what consumerism does, I think, and what I do, I'm the CEO of the Oregon Professional Liability Fund, and we insure all the lawyers in Oregon in private practice, every one of them. So I see all sorts of aspects of people who work in all kinds of different practices. And what it does is it puts, because the way that people get clients now tends to be different. It comes through advertising, it comes through, people read Yelp reviews, which we'll talk about a little bit. They do all sorts of things to get clients, especially for small firm and solo practitioners. I think that a lot of the pressure comes into that group rather than big firm folks. So how you get clients is very different. The competition is very different. That puts economic pressure on everybody, which is different as well. And what that sort of implicates is how you choose your clients. Client selection, I think, is not as easy as it was when you were in a community and you actually knew people and the referrals were personal. When they're over the internet, it's a very different kind of relationship that begins. It also puts pressure on people to perhaps expand their area of practices, which causes risks for people in terms of malpractice. It's created just a number of issues for people as well in just how you deal with social media. And sort of the first question is, what can go wrong when you're dealing with social media and when you're using those kinds of mechanisms? And you can breach client confidentiality, you can get involved in prohibited communications very easily, and I'm going to talk about some of these things specifically. How you do investigations is different. If you do look at somebody's profile, social media profile, how do you do that in a way that is legitimate and ethical? How do you advertise? What can you say? Are you starting attorney-client privileges, relationships that you're not really aware of? And what kind of conflicts do you have to think about when you're doing that sort of thing? And those are all risks, because although the practice of law has changed in the sense of how you present evidence and how you gather evidence, those things have changed as well. The ethics have not changed, and the ethical rules are being applied in areas where it's just not clear to people in the same way it was when you had a client sitting in front of you, or when you checked conflicts on your conflict list. It's just different, and I think it does create a series of issues. I mean, just to start out with an easy example is how many people are on a listserv here? So a modest number, maybe a third or so of people are on a listserv. What can you put on a listserv when you're asking for help? Can you put down, how many facts can you put into a fact situation? Can you say something which, I mean, you can ask for help. The ethical rules allow you to do that. But I wanted to read you a listserv that somebody put up in Oregon and was disciplined for. So just give you an example of the kinds of things that people do. Client, I'll call him Bailey, works for a government entity in a small town. Bailey is disabled, and his medical marijuana card, I don't know if you have medical marijuana here, but we do in Oregon. Employer does not know about Bailey's disability or that he uses marijuana, sometimes before work because it eases his back pain. He does truck deliveries, and sometimes the lifting is difficult because of his back. HR recently issued him a warning because he's not meeting his delivery deadlines. He also recently received a ticket for running a stop sign. He wants to know what to do and doesn't have much money, so was referred to me through the Modest Means program. I am new to this area of law. Help. Well, in a small town, you could theoretically know who that person is. That's one issue. It's clearly that there's questions of competency and involved in this as well. And if there was a malpractice lawsuit, I think this is discoverable. And when a jury hears, I'm new to this area, help, defense gets a little bit more difficult in those kinds of things. But the real point is that you can go wrong in something as obvious as a listserv. And in Oregon, and I assume this is true here, the estate planning listserv, defense bar listserv, criminal law listserv, everybody has one. And I'm sure you've seen things on that have given you all pause. And that's like one very specific area where people have problems. There's really good guidance for this, and there's an ABA opinion from the Standing Committee on Ethics about what you can do in terms of giving other advice that's good. And it's 98-411 if you're interested in that. Another area, and I'm going to just start on some of these things, and I think we'll get into them more, that is of real interest is investigations in other people's social media. What can you do? I think it might well be malpractice not to look at an adversary's social media profile. There's things that you could find out there that you might be very valuable in the defense of a case or prosecution of a case. But what can you do? Can you, if the person is represented, can you go to their site, even though you know they're represented, and just look? If the person is represented, can you friend that person? If you are straightforward and just say, hey, I'm so-and-so, I want to be your friend, can you do that? In Oregon, you can. I doubt that you could in Wisconsin, just reading the rules. It differs from state to state. How do you manage those kinds? Can you have somebody else go to a site and say, you know, a paralegal, and say, I want to friend somebody? Can you do sort of a covert action and do those kinds of things? And the answer is to those things sort of no. for the most part. But I think that they all are implicated when you talk about social media. Some of the other areas that I'm going to get to later is advertising, what you can do in those sorts of things, conflicts, when those conflicts are created. So that's when we'll get to those things later.
Ira, I know you also, you had brought up when we were talking last night about online reviews of lawyers.
Right.
Like a Yelp review. And we'll talk about this as we go too. And I don't know how many of you have experienced anything like that, but I know you have some thoughts on that type of thing.
Right, and how to handle those things I think is really important. So.
And I had read, I don't know if any of you saw it, I think it was in the ABA Journal online stuff. A lawyer, I can't remember where he was located, he saw a bad review of himself on Yelp, and he sued the person who reviewed him. I think that's still pending. I have no idea what the outcome is going to be, but I found it to be quite an interesting story. I mean, how do you, first of all, how do you stop somebody from doing that if you can at all? And what's your recourse? You know, suing the person, I guess, is one way to do it, as that gentleman did, but I don't know what the
I believe that gentleman ended up paying $80,000 in attorney's fees. It did not work out well for him. But there are things you can do, and we want to get to them now or later.
All right. Jeff, you do patent law. I think most of your clients probably involve more than one person. You deal with business entities and so forth. Tell us some of the things you see in your practice in terms of client expectations and the confidentiality stuff that I know you deal with pretty regularly.
Right. My clients are typically large corporations, both here in the United States and abroad, excuse me. And in some cases are companies with offices both here and abroad. I also deal with attorneys in just about every country you could imagine at various times. And they all have different expectations for how they want to communicate with me and with amongst themselves. And I try to accommodate them the best I can. I'll deal with emails. We have telephone conferences at odd hours to accommodate different time zones. All of those kinds of things are fine with me. I don't have any problem communicating in any way they designate up to a point. And that point is if they choose a method of communication that could possibly risk violating some rule of confidentiality. For example, the rules of professional conduct here in Wisconsin, 20.1.6 prohibits you from disclosing your client confidences. Well, if a client in another country says copy so-and-so on this, he's a local distributor, I want him to have information that I'm sharing with you, I would typically advise him not to do that. It could violate not only the confidentiality, but attorney-client privileges and so on. So there are lots of things you have to do and be aware of that while you're trying to accommodate them, you also have this baseline consideration. These issues arise many times in not only telephone conferences, those kinds of things, but in obviously written communications as well. Telephone conferences, this is a little bit old school, but not high tech at all, but to have conversations where people who need to know or aren't going to be involved in a privileged conversation might have access to at least part of the conversation. It could be a cell phone conference out in the hallway. It could be a door open in a corporation and people down the hall listening to what's being said. And those are the kinds of things that I try to advise clients on and limit the exposure of those kinds of communications. Simple things. Close the door. Go out to the parking lot. Make sure there's no one around when you're talking. Recently, I don't know if it's just me, but I've noticed many people, even when they're just by themselves, using conference phones. And I don't know why they do that. And maybe it's just easier on them. They listen to people on the phone all day and they don't want to do that. But the volume of those things is sometimes so loud that it can be heard literally through corporate walls. And so I do try to encourage them that when they're talking with me or any of their other attorneys, to pick up the phone or at least turn it down, make sure their doors are closed, and limit the exposure of that communication to the people who need to know, and just the people who need to know. And That's true, really, of writing, too. You definitely don't want to put anything in writing that's going to be distributed to somebody outside that need-to-know group. You can actually waive the privilege in a corporation if you distribute a communication beyond really what's necessary. So if there's in-house corporate counsel, for example, and you're also copying people who work in the warehouse or salesmen who don't really appreciate the attorney-client communication and the reasons for keeping it confidential, then that might be considered a waiver. And even if it's not, it could be something that you have to squabble over in litigation, and that's going to expend a lot of resources and waste a lot of time. So when it comes to things in writing, I start with something that was beat into me very early on in my career, and that's that you don't put anything in writing that you don't have to, and you don't put anything really negative or speculative in writing if you don't have to. And it's so much easier these days to be putting things in writing that shouldn't be put in writing with emails, for example, because you're not actually preparing a formal letter that's going on letterhead that has to be printed and signed. It's so much easier to sit there and type into a computer and hit a send button. But the same rule applies. Be very, very careful. And you don't have to be a lawyer really to understand that. It's in the nightly news. The IRS got in trouble with some emails that they had sent around internally. And so it's pretty easy for clients to understand that. And in fact, they do a pretty good job of it. When I enforce with them that someday they may be sitting in a deposition having to discuss whatever it is they put in writing, then they get a little nervous about that. And I say, even if you don't care about yourself having to answer questions, think of the poor lawyer who has to defend your deposition. That would be me, and I don't want to have to do that. So I do caution them. Interestingly, most of my clients who are not attorneys follow those rules pretty well. And if they need a subtle reminder once in a while, they're pretty good about it. Some of the people that I communicate with are lawyers in other firms, and they're some of the hardest people I've had to convince that that's not a good thing to do for whatever reason. But for the most part, it's something that if you keep it in mind on a regular basis and remind people with subtle reminders, they'll abide by. As far as putting negative things in writing, obviously you can't be avoided entirely, but those are things that you can put into a more formal document, and it just is a constant reminder as you're preparing it that it's something that you really want to be careful with how you craft it, make sure you've got all your legal support, and make sure you're not disclosing things that are unnecessary to disclose at any particular point. And when you distribute that document, whatever it may be, say a written opinion, for example, you send that only to a need-to-know group of people, and you remind them with headings that it's privileged, attorney-client, it might be work product, that they're not to distribute it to anyone outside of the group that's listed there without at least trying to talk about it first. That's difficult to do in some corporations because if a senior person from another division comes and asks somebody for a written opinion, he wants a copy of it, he'll usually get it. It's not that difficult to understand why, but at the same time, you do have to remind people and keep them on course for how important it is to maintain those confidences. Now, as I mentioned, the emails are really the toughest place to keep that in mind. I actually was involved in one lawsuit where the whole lawsuit really was started because of an email. And it was funny actually, it was hilarious, but it was insulting to the recipient. And he then cut off negotiations and filed a lawsuit that turned out to be very, very expensive over the course of several years. And even humor in an email might be taken wrong, and it might be something difficult to talk about in a deposition. Is it admissible in court? Maybe not. Is it something that a lawyer on the opposite side of a deposition might start asking you about to throw you off your game first thing in the morning? Yeah, maybe he'll embarrass you or she will embarrass you with an email that you're not too proud of. So even things that aren't privileged or confidential or all that particularly business sensitive are things that I actually try to keep out of emails. Emails also can easily be redistributed very easily. They can go to a select group of people and then get forwarded very easily, either accidentally I have autofill on my to line, and I have to be very careful. If I type in the first couple letters, somebody's name pops in there. Very easy to send some kind of correspondence and send it to somebody who you didn't intend to send it to. So you have to be careful with that. You also have to be careful of a disgruntled employee leaving the company and either going to a competitor and taking that information with them, or forwarding it on intentionally to do harm to his own company. And so those are the kinds of things where email troubles me still. It's not something you can avoid. Email is here to stay, but again, it just reinforces how important it is to limit what you put in writing.
I just want to add two really quick things, if I might,
Sure.
about email. And one is, I've seen a number of lawsuits with the dreaded reply to all that's gone to the wrong people, and I'm sure everybody's done that and seen that. But the other thing that I've seen in one particular lawsuit, where somebody did not know what the thread said, and they had a very long thread, it talked about a host of other things, they sent that to the wrong person, thinking they were only sending a very limited piece of information. So people need to be careful about those things as well.
Mm-hmm.
And then on the writing things, I think that it's absolutely true. When you're communicating with other people, you need to be very careful. But from the point of view of a malpractice carrier, you should be documenting your file about what you do, because it's very hard to defend somebody who hasn't done that. Okay.
Yeah, I agree. And notes to the file are fine. It's much
Right.
harder for those to be discovered. In fact, when it comes to email, I tell my clients, call me. Literally, call me anytime. And I've had calls from trade shows, bars, at 10 o'clock, 11 o'clock at night on a Friday. Some competitor came up and told me we infringed their patent. And I said, good, I'm glad you called me, and we can talk about this, and I can tell you how to respond right away. I really do try to make myself available so that they don't feel that email is the only way they can reach me. I want them to know they can pick up the phone and ask me a question. My clients are clients that I have for many years, and I'm very fortunate in that regard. And I even go so far as to tell some of them, look, call me. I'm not going to charge you. If you have a question, if you have something that is urgent, that just popped up, that's scaring you, I would rather you talk to me than put it in writing, or think that you've communicated with something to me and I'm even out of the office. At least if you try to call me and you get my answering machine, you know I'm not there. And you can leave a message and I'll get back to you as soon as I can. But those are things that I try to do to help clients feel that email isn't the only way they need to reach me. I still have clients who fax me. I still have clients who send mail and ask me to send mail, especially bills. They want bills mailed, they want everything else emailed. But it's still a way that the clients know that I'm available for them whenever they want. One other thing that's come up recently that I'm not real familiar with and not real comfortable with yet is that when we have telephone conferences with people in various locations, we're going to have a conference with somebody in Illinois, Wisconsin, Germany, Russia, literally in one conversation. And it's difficult to get documents distributed in time for the telephone conference, and so there'll be a document share site where everyone can visit and use a password and get in there and see the information that's being shared. These sites, I'm told, are very secure and very useful for some people, and I've used them on one or two occasions. I have some considerations, though, and some thoughts on those that I really would like to share with my clients at some point if they continue to use this service, and that is, number one, how secure is it? Who has the password to it? My IT guy reminds me time and again that you may have the most secure server, most secure website in the world, but it's only as secure as your password. So are your passwords secure? Are they something that can easily be decoded or guessed at? And those kinds of things. And so I do wonder about that part of it. Just how widely distributed is a password for a particular bucket of information is what I'm told they're called. Also, what actually goes in there? Are these documents that are publicly available? Are they documents that were filed in court? Things that aren't really confidential and you're just going to have a conversation about? Or are they documents that include attorney work client, work product, or privileged information? So if you have that kind of information there and it's available to the folks that are on the phone conference, just how long is it going to be available? Is it something they can download and so on? Really, I think you need to be cautious about those kinds of things because you don't know who you're sharing it with. Whoever has a password to that bucket of information can see your work, and it's something to be considered. I also wonder how long those sites, those buckets of information are available. I'd like to see some sort of self-destruct button on them. They last for 10 days or something like that, and afterwards they have to be refilled if you want to talk about that information again. And that way you know that it's really going to be limited as far as how often people can get back in there and
Jeff,
view it.
can they be downloaded and worked on at somebody's, and then gotten to the rest of the world through the computer at the company?
Well, that's a good question, and I don't know. I don't know. So I think in some cases, yes, and some no. And I think if people are told not to, by and large, they won't. But that doesn't stop some people, as you know. So those are some of the considerations that I have involving accommodating our clients and the ways they want to communicate. I will bend over backwards to deal with whatever situation or whatever communication mode they choose. But there are these baseline considerations that we all have to keep in mind.
Thanks, Jeff. Sally, you live in the world of claims, so I know you have lots of horror stories, and I think we have a question, do we
I have
not?
a question from one of the web viewers, and I believe this is directed to Ira. The question is whether you see any problem with accessing an adversary's social media like Facebook for information that's not designated private, where you don't have to say, can I be your friend?
Most ethical opinions would say that's fine. It's just like reading a magazine article. It's public, it's out there, and that's fine. You can do that whether that person is represented or not, probably, as long as you don't have any interaction.
There's a ABA opinion from April of this year, formal opinion 466, that in fact discusses that and says in part that's the thing.
I just want to make one quick comment about storing things in the cloud especially, that Google, for example, if you store something in the cloud with just your normal Google account, you don't have a professional account, Google claims ownership of all that material. And whether that constitutes a waiver of some sort of attorney-client privilege, it's available. I think that because they do that, it's best that you don't store it in a Google normal, just regular person account. But I think you do need to really investigate how secure those things are. Dropbox is very secure for the most part. Some of the others are not. So,
Any other questions from either the room or the web? Okay. So Sally, you see the end result when things go sideways, and the title of this program is the increasing client expectations, how they're more demanding. As one person I was talking to this morning said, they're more whiny. Having done divorce law myself years ago, I know exactly what you're talking about. So are clients more demanding, and I mean, is that what you're seeing in how things can go sideways in these claims?
We're seeing different kinds of claims than we used to see, not overall, but certainly in areas and different kinds of complaints. So it used to be a missed statute of limitation, and you could try to figure out how to value that the damages in a case where there was a missed statute of limitations. It was pretty straightforward. That is not true anymore. The kinds of claims that we get are not straightforward. And so when I am dealing with issues, there are very many shades of understanding of what was the lawyer actually hired to do in this case, how far should the lawyer have gone to get information about the client's goals in a matter, because very often what a client tells you that he or she wants you to do is not really what they need. And they may not figure that, so you may do exactly what you've been requested to do on behalf of a client, and they find out later that in fact, that goal would have been, the real goal would have been better accomplished in a completely different way. And then guess what happens? Years later, when the client figures out that a completely different way would have been better, then we get calls about that, and the lawyer will say to me, but I did exactly what the client wanted me to do. Well, I see that as a miscommunication. And the problem with that is that, as you've been hearing here, those communications are more challenging now than they used to be because we do it much more informally than we used to do it. We don't necessarily know the people we're dealing with. You've heard that before too, and you know it in your practices. That opens the door to all kinds of slips that we didn't have when we knew the people across the desk from us, and we knew kind of what they were about anyway, because we live in the same town, we deal with the same people, we have the same kinds of needs here, and we get that. So with all of that off the table, then you say, all right, well, so what's happening? We're seeing all kinds of claims. Used to be that estate planning and probate was safe, safe, safe area of practice. No big deal. We have seen claims in that area of practice go bonkers. And what's happening? What's happening is that the baby boomers are getting older. There's a fairly large transfer of wealth going on. If you haven't figured this out, let me be the first to clue you in on that. And that there are lots of children or other beneficiaries, or thought they were going to be beneficiaries, who are fairly disenchanted with what went on. And rather than start a war in the family, which may already be going on, it's one of the places that people can get together and do something is we can band together, be on the same side, and and make the claim against the lawyer. There are lots of people involved in these issues. They're almost always dysfunctional family issues that we're dealing with in those kinds of issues. And lawyers can't, in my opinion, lawyers have a really hard time staying out of the pot when those things start boiling. There will be fingers pointed at the lawyer. So what do? Well, you document your file as well as you can document your file. You think it through carefully. You work with your client to be sure that those clients' goals are stated and hopefully maintained in some way. I don't think it's quite as bad yet as many years ago. There was a lawyer from New Jersey who told me that it was malpractice for a lawyer not to videotape the signing of a will. I don't think that's the standard of care in Wisconsin yet. But if you think about that, there are some things that could be said and stated, and seeing it on a screen in front of the kids at a later date could be a powerful thing to do. Maybe it's something that people ought to suggest to clients that we talk about if this isn't normal operating procedure that's happening here. So estate planning area, big deal. I'm frankly scared to death about the new trust law that just passed here, that just went into effect. The idea that you can have a trust advisor or a trust protector and change the terms of the document, and that the lawyer who drafted the documents is going to be the lawyer who's appointed trust protector or trust advisor to change the documents at a later date, that, from a legal malpractice standpoint, scares the bejesus out of me. And I'm just waiting for those things to start bubbling around. And it's interesting because when I talk to estate planning lawyers, they say to me, but our clients want this. We know them. We know the family. We're equipped to do this. And my response is, you're also taking a huge risk. It may be what your client wants. You may be willing to take the risk. But know a couple of things. Know that in Wisconsin, we have a rule of professional conduct that's unique to Wisconsin and appears nowhere else. It's in the materials, but it is, it's 20:7.3E. What that means is, it says, a lawyer at his or her instance shall not draft documents such as wills, trust instruments, or contracts which require or imply that the lawyer's services will be used in relation to the document. There is an old ethics case, the Gulbenkian case from 1972, but it's been quoted recently, so it's still good law, that deals with that kind of issue. Estate planners ought to know about this, and I don't think that was part and parcel of what was discussed in the law. So just because the law says you can do it doesn't mean you're going to be protected from claims in the process of doing that. That law also says you can say the person who's doing those trust advisor, trust protector kinds of roles is not acting as a fiduciary. Well, let me in on a secret here, and that is, I can't imagine any court in this state letting a lawyer in those positions out because they aren't a fiduciary. I'm sorry, I think the lawyer is a fiduciary. And I think the courts will probably see it that way too. So be careful with that kind of stuff. That's one of the areas that's burgeoning
I
at this
would
point.
also say that in Oregon, we're seeing state claim, and also burgeoning, and I think that one of the problems with the social media stuff and the communicating in emails and the sort of stuff Jeff has been talking about, the malpractice claims have always been, a lot of them are about communications with clients and people's failure to communicate with clients in a really good, accurate way, in a way that generates trust. And I think it's much harder to generate trust when you're using social media, when you're using emails, and what that means is that you have to take real special efforts to be in contact with clients. Having Jeff's suggestion that you actually talk to people on the phone is a great one. But I do think that you're looking at the same kind of dynamic, but it's really exacerbated by the fact that you're just sending things back and forth.
Yeah.
It's very easy to misinterpret written things. So that's especially when you're getting clients through services and all those sorts of things, it just makes it much more difficult. So.
I read a state bar program in Lake Geneva recently. I was on a panel, and one of the lawyers was talking about how she does a lot of, I guess, what you'd call virtual lawyering. And she said many of her clients she never actually meets face-to-face. And I know Ira and Jeff, you guys probably can speak to this. What do you think of that? It generated a lot of conversation in the audience that day. Some lawyers being very I guess, hesitant about it when you actually have clients who you never actually meet. And I know, Sally, you probably recognize the red flags to that, too.
Strong feelings here.
Yes.
Yeah.
So you want to talk a little bit about that? And I don't know how many of you have encountered that sort of thing, too, and maybe that's something we can talk a little bit about.
I think one of the issues there is how you got that client. Mm-hmm. Where did they come from? Have you advertised? Have you, are you in the right jurisdiction? If they ask you to do something that you're not really comfortable doing, I just don't know how you get clients, and I think that we'll talk about that later maybe, that is really important. But never seeing a client, I think it's very hard to know what's right for that person, what you can, what they really want. I just think it's a difficult circumstance. But I do see a number of people who never see their clients, or see their clients in a divorce, that when they go to the, unbundling is another area where this is really more common. In domestic relations, you might unbundle and do one small part of something and not really get to know the client at all. And I think that you can talk about that later as well. And unbundling is just doing one part of a series of things that need to be done in a particular manner.
Right. I have a lot of clients and lawyers that I work with I've never met. They're in other places of the world. I travel there sometimes and get to meet them, but not always. And even here in the United States, I had a client in Ohio I worked for 9 years and never met face to face. It's not uncommon, and that's been going on since the beginning of my career. What it does, though, is it reinforces the need for good telephone skills and making sure that those communications are solid and that everybody feels they're on the same page. And also, when you do write communications back and forth, that those are as detailed and accurate as possible. And keeping your files well papered with your notes and the history of a transaction that could take place over 8, 10, 20 years. And if you go back to a file, if somebody calls up and says, hey, back in 2006 you did this or that for me, I literally might not remember that matter at all, but if I can find the file and my notes are clear enough, we can get up to speed very, very quickly. So those kinds of details are very important when you're not going to see a client or ever meet them face to face.
I think it does depend on what you're doing for that client.
Right.
No question about that. On the other hand, if there's an opportunity to meet a client, think about how we communicate. I mean, you have so much of what's going on, even in this room right now. Some of you are yawning. Some of you are engaged. I used to teach high school, a psychology class in high school, and I used to say, if you really, you can fake me out, lean forward, nod once in a while, and I'm going to think you're listening to me. So that's a really good thing. Body language is an incredible tool for communication. So if we don't ever see our clients, we're going to take that huge piece of the ability to communicate, so that if someone's actually, see, I think communication's a two-way street. It's not just what you put out there, it's what the other person receives or hears or understands. And unless both of those sides of this process are working in sync with each other, you don't have communication. We just have an illusion of communication. And lots of lawyers think they've communicated when they haven't communicated at all. Now, so we get rid of the body language stuff, then another maybe 30% of our communication is inflection. I grew up with a mom who never said yes and never said no, ever. 4 kids she raised like this. She said, I suppose. But every one of us knew if I suppose meant yes, it's okay, no way, Jose. We all knew. Why? Because the inflection was so powerful. So if you can talk to your clients on the telephone, you're picking up, you've got that piece of this communication, and you can hear the reluctance, or you can hear the question in the voice, or you can work with that. If all you're working with is email, you have lost 90% of your ability to communicate with the client. And now we're working on just this paper record. Now, for some kinds of issues, that may be plenty. But are you a commodity at that point? Because do I care what lawyer I use at that point if it's just on documents? I've wondered that.
Gotcha.
I actually just want to make an observation. I think these communication issues are primarily client-driven. So I'm guessing there's not many, if anybody in this room, who isn't wishing they had these opportunities for face-to-face meetings and at least phone conversations. I just think the pressure is coming from clients about, our expectations are just so high for quick response on everything.
I think that's right, and I think it's easy for us to say we should communicate face-to-face. But this is about social media, and that's not really an option for everybody all the time anymore.
Clients are making you do this stuff, so how can we do this more safely?
So the deal is doing it safely and doing it in a way that you've documented your file, your client knows what you're doing, and they trust you to be doing the right thing.
Right.
And also following the ethical rules, which really are a minefield in a lot of this stuff.
Absolutely.
So I think that those are all things that we just need to continue to talk about. So, speaking of sort of just in the minefield world, one of the things that does happen is we mentioned earlier, the Yelp stuff, where you get a review that says, and I have an example one, but basically it says, this is the worst lawyer in Santa Monica. No, this is the worst lawyer in California, and they're horrible, and they're just going to steal all your money. And this is a Yelp review of this lawyer. And what do you do? What can you do when that happens to you? One of us wrote a review of this hotel and said, "Oh, I think there's bed bugs." It would not help. And there's analogous things that someone could say about your representation and be completely wrong and just be a troll of some sort. What can you do? Well, what doctors do, and I'm not recommending this, but I think it's interesting, they basically have in their informed consent agreement, they say, you can't review me. You just can't do it. It's part of our deal, you can't review me. One of the other things that doctors and dentists do, and this is I've stopped doing this, I think, is they say, if you do write a review about anything that happened in our relationship, I own that intellectual property. It's my intellectual property. And what that allows you to do is to do a takedown notice. If Yelp sends something up there, it's a review, and you say, I own that, you can write them a letter, and there's a whole, and Yelp has on their site how you can try to have something taken down. So you could do that. I do not recommend that for lawyers. I think it may well not be ethical. I think there's clear rules that say you just can't tell somebody, you can't own their intellectual property that they develop. I just think you can't do that. But you can respond. And I think that the best practices talk about how to respond. And for the most part, what people are told to do. And this is just communication too, but you're communicating not only to the person who made this, but to the public. And it's important how you do that. You can get in contact with that person if you know who they are and say, what's the problem, and maybe get them to take that down. You can do that. That's a possibility. Another thing you can do is you can say, this isn't true, but if someone's made an anonymous evaluation of you in Yelp or some other place, how much can you say in the notice that you're responding to? You cannot, if that's your client, you cannot breach that client's, or maybe can't breach that client's confidentiality. You may not be able to say all the things you want to say. On the other hand, there is in the ethics rule, it says that you can respond in your own protection the way you could in a malpractice suit to controversies of which you're a part of with the client. How far does that go in the Yelp or this sort of review world? I don't know. But I think you need to be very careful that you don't say something in a response that breaches the confidentiality of that person. Mostly what people say is, I'm sorry that this happened. If it was something that we can fix, we have. That they're very sort of bland. And the other thing that people try to do is to get the clients that they've worked with who like their work to write a review. Because what happens then is those reviews get moved up in time, and the bad reviews get moved down in time, and it works in the lawyer's benefits when you do it that way. But I do think that I was looking at Yelp in Oregon, lots of lawyers have reviews, and they're not all good. And I know when I look at a bed and breakfast or a hotel, and I try not to respond this way, but 2 or 3 bad reviews get my attention, even when there's 7 or 8 really good ones. So I think it's important that people monitor that. There are services that monitor it for you. One thing you cannot do that the ethics rules clearly forbid you from doing is having one of those services write a review for you that isn't really reflect reality. You just can't do that. People have been disciplined for doing that. But I think that whole area is something that we'll see more and more in the sort of coming years. So.
I think the statistics are now that more people are finding lawyers on sites like Yelp than any other way. So if you talk to clients about how a brand new client about how they located you, it's probably going to be through a review service someplace. So it is important what goes on there. It is important. And it's not, the hotel, when you complain about bed bugs, can write a reply and explain that there aren't any bed bugs, and we've had the dogs in and sniffed out all these rooms, and we're really sorry that this person wasn't happy with things, but it really wasn't us. A lawyer has a much more difficult time.
You really are constrained by confidentiality rules, all sorts of things at that point.
I think that's all true, but I think also Katya's point goes to the heart of one of the reasons we're here, and that is, I think there are lawyers in Wisconsin, at least from my interactions with them as I'm out, that probably some of them have never even heard of Yelp, and they're not aware of the expansive online world as you guys are talking about it. And then there are lawyers who really are in touch and really in tune with it. And as Katya pointed out, this is being driven by clients as opposed to the lawyers, and it's up to the lawyers. And again, it's one of the reasons we're here, is lawyers have to figure out how to respond to this and embrace it and make it become part of their world, right? I mean, Sally, in your materials, you talk about the quote new environment, and that's a new environment, don't you think? That's being driven more by the clients. And by the way, for those of you on the web, the materials, you should have a link to the materials. So feel free to click on that to look at this. So there's some good stuff in there. But this new environment, again, was what we're talking about.
I think that's really true. And I think one of the ways you figure out your place in this new environment is to figure out, okay, what worked before? Now, what do I have to change to make that work now? And one of the things that I see frequently, and we've touched on it, but email communication, which of course is, I would think there probably aren't a whole lot of lawyers in the state of Wisconsin who aren't using email in some way, shape, or form with clients. But we have, the issues that I see in claims with emails are things that come up because of, somebody, how you know how it's so easy to press the reply button, so whatever the subject line is, stays the subject line forever? 6 months, 8 months, whatever. How in the world are you ever going to figure that? And how many emails are attached underneath that are still gettable after, you know, they're still attached to this thing, although we may have changed topics 12 times, it still says, you know, that this is about whatever that first email was about. I think lawyers need to learn to control how they use those kinds of email, how they use those programs. How about starting a brand-new email when there's a brand-new topic and calling it what it is? And keeping that line separate and distinct so you know what's going on there. I'm finding, particularly in divorce cases, that email is causing all kinds of problems. In the olden days, I had a lawyer I knew who did a little bit of divorce work because general practitioners in small towns did a little bit of everything. And his rule was never take a call from a divorce lawyer on Monday. And that worked pretty well because by Tuesday, all the terrible things that had happened over the weekend were kind of settled down and everybody was back to being normal again. Well, now what happens is the divorce lawyer gets 17 fuming emails about what he did or what she did over the weekend. And so you come, if you've been monitoring your email, which you probably have, you know that, do you respond to each and every one of those emails? Gee, I hope not. Have you talked to your client when you took on this client, when you did a retainer letter, how you're going to respond to those kinds of emails? You know, are you keeping things straight, and do they understand what your role really is in dealing with the problem that's, you know, you want to vent, that's fine. Go right ahead. Those are also the clients, because they're so hyped up about what's going on, they're going to forward everything to everybody on their list or post it on their Facebook site, because that's the way we display and dissipate our anger these days, you know. Those are issues for lawyers to say, okay, you know, pull back. We got to get in control of these things. This is how we do it. You know, you communicate with me. It doesn't go anywhere else. Forget you have a forward button if we're going to communicate like this. Make your communications as professional as you can. What I love that I'm being snarky about that, but I really have a hard time with, we all want to look a little smart for our clients, and we all want to be a little cozy with them if we can. I mean, that's part of the relationship building process. So when you do that online and you do the business part and then you make some crack about opposing counsel or the judge or the, you know, whatever it is, and I see those now when a claim is made and you get this whole pile of emails that all have the same subject line, and eventually you get down to all these cute little comments. And believe me, it is a problem. These are professional communications. And the more we understand that and treat them as that, the better off we're going to be in this new landscape.
So we had a case in which somebody made a number of snarky remarks about the opposing counsel. They weren't really very good, et cetera, et cetera. Those became a tremendous obstacle to settling that lawsuit. And the first thing they went into the mediator when they talked about this case was not the merits of that case. It was, they said this about me, and I want blood. And I think you just have to be very, you know, the lawyer probably wasn't a great lawyer, but it really didn't matter, and it really did compromise the settlement of the action. One of the things about being cozy with clients, and I'm just throwing this out to see what people think, should you friend your clients on Facebook? And people do that. There's two schools of thought. There's people who I see who are very big lawyers, who are very big into social media, say you should friend them, you should talk to them, because what is going to happen is you're their friend, their friends are going to see who you are. You're going to get more business if you friend your clients. I think that it's fraught with difficulties because you can say things, make things, to create client relationships with people you don't even know in some ways. But it is a question. Does anybody here friend their clients?
Would
Oh,
you
good.
dare say?
Right. But it's something that people do.
You're talking about client communications now.
Right.
Out in the open.
That's right, out in the open, friendly clients, and, people do that.
Well, and the other way around too, I have a friend who is in a similar position to Sally's at another company like ours, and I think we're friends, but what he keeps posting is business things. So it's clear that he is, I like him very much, but he's trying to make himself look good and generate business, and it is so irritating to our friendship that don't do that either. If they're really your friend, stop trying to sell yourself as a great lawyer. I think keeping those worlds separate is difficult and important.
But it is a marketing tool. And a lot of what people do on social media, tweeting is a marketing tool. And you can go wrong with tweeting. And one of the things that happens with, I don't know, does anybody here tweet? I personally think I was asked to be on this panel because I have 30 followers. So,
You had 29 yesterday.
That drew us to you immediately.
That's right. But tweeting is for many lawyers, it's an advertising thing, and they tweet about their successes, they tweet information about cases that make them look smart, you do this, I do that, but they get tweets back from people that say, what about, can you help me with this problem? And in that context, it's very easy. If you answer in anything but the most general of ways, you've now potentially created an attorney-client relationship with that person and all that comes with it. And the nature of your advice, which you've given in 140 characters, might not be great. There's all sorts of things that happen when you do those things, and you have to be very careful. Yes?
I have kind of the inverse comment that I feel a lot of pressure to say yes to a friend's request from one of my corporate clients' general counsel, because her other counsel who provides services all friends her. So then if I'm the one who didn't friend her, then I don't know the little, what are we all talking about? Did you see my and I found it uncomfortable. I didn't want to be a Facebook friend of this person who I only have as a corporate client, but how could I not, right?
I think it's a business judgment in some way. It just is.
Right.
And it's a marketing issue. I think that a lot of people are friends in that kind of context.
Right.
You could have a professional page probably, or you could do it that way,
I just
maybe.
don't post.
Sure.
And what do you do, right?
But the tweeting thing is, I wanted to mention one other thing because I think it's sort of interesting. I have, in Oregon, there's a huge lawsuit going on now between a very aggressive plaintiff's lawyer and BP. And there's hundreds of millions of dollars at stake in this lawsuit. It's been going on for years, and there's literally hundreds of millions. And he tweets, this tort lawyer, he tweets about it all the time. And he tweets and says things like, BP has destroyed evidence and I'm going to bring them down. Or the evil empire BP does this, does that. And he doesn't, I mean, I could find him and read them to you, but is that a violation of publicity? Now, he's got probably 2,500 followers. Maybe not. But maybe if he had 10,000, it would be. So there's that kind of, I don't know what it is, puffing, I suppose, that people do in tweeting. He's trying to get clients, too. He's doing God's work, and he wants everyone to know it. And he's aggressive, and boy, I want to go to him if I have that kind of large institutional tort case. So I think you have to be careful about what you say in all those instances. But I will say, I suspect he's gotten more clients than any bad thing that's happened to him from that.
Probably.
Is this a generational thing, do you think? I think of my two late 20-something sons who don't answer their phone, but when we text them, they respond immediately.
Well, he's my age. I don't know. He's not quite my age, but he's in his 50s, so I don't know. I think it's a marketing thing. Some people are just aggressive in marketing and like to be out there in the world.
I think some of the emailing is generational. I've noticed when I've hired paralegals who are substantially younger than me, they'll be sitting 15 feet away emailing me. I'll stick my head out the door and say, come on here, let's talk about it.
Right.
So I think there is some of that. Yeah.
What do you think, Sally?
Well, oh my. I'm still stuck on the tweeting lawyer against BP, It would, I think the OLR here would be all over somebody for that kind of stuff, and yet I'm sure it happens. And I'm sure there are people who are making those comments about their cases all the time. Our confidentiality rule is pretty broad. It says anything you learn in the course of a client retainer, you can't talk about, and I would expect that means you can't tweet about it either. So I think the issues are, it's interesting. Ira said earlier that the ethical rules are still there. They're still the same. They do apply to all of this stuff. But the smart lawyer is the one who's going to figure out what it is that I want to use, how do I want to use it, and how can I make that work in an ethical way. Now, that's one of the reasons that Tim Pierce's telephone number is on my speed dial. But because there are so many things, and that we do have resources in this state to help people figure out the answers to some of those questions, or at least how far they can go right now. Yes?
Yes. Can you get a microphone on her? I'm sorry.
What do you do with the difference between?
Just want to make sure the web people can hear you.
They're not hearing questions, so you either need to wait for the microphone or you need to repeat.
My experience is with younger, not just younger clients, but also people who do not have laptops, people who are using these iPads or smartphones only, will only text. And I'm not comfortable with that texting concept, but that seems to be some parts of our society, that's the only way you can communicate with them. Like you said, they won't answer phone calls, they don't utilize email, and they want this, and you get all these texts that you haven't been reading all day, and some of them are quite important. What happens to those texts? How is that used as evidence? What are you supposed to do? I tried once to communicate with a mass reply, I do not respond to texts, please do not send me texts, and they are offended by that, and it doesn't seem to have any impact. So what do you do with all these people who communicate this way?
Mm-hmm. I think that's a really good question. One of my favorites in a very strange way recently was a lawyer who had problems with OLR because there was no fee agreement. And of course, that's a pretty clear rule that you need a fee agreement. Well, the lawyer said, but there was a fee agreement. It was in a text message.
And is that written?
Well, it wasn't retrievable, which was a problem.
You could print it.
You could print it, yeah. And he probably should have printed it, but he didn't print it, so it wasn't retrievable, and he couldn't prove that, in fact, he had had a 140-character fee agreement in this case. So there are some things that it doesn't work for.
Right. And are they confidential? Can they be hacked and read by others? I think those clients, if it were happening to me, I would have a talk with them and say, I understand that that's a common way for you to communicate, but it's not going to work for me, and here's how it's going to have to be. And explain to them their own pitfalls and what could happen to their information if they do that. I don't know how receptive they'll be. It depends on how stubborn they are, I suppose. But that's, I think, we're a starting point at least.
Jeff, I think that's a good point. I guess my question, though, would be your clients, they're defining what they think would be good service from you, and you sort of don't have the control over that. What you're saying makes perfect sense, Jeff, but in a way, how do you combat this tidal wave of momentum in which we're finding that clients are really defining what the good service is, as opposed to the lawyer says, here's how my service is going to be done. In other words, when we were out to dinner last night, we have a perception of how good our service was at that restaurant. They don't get to tell us whether it was good service or not. You know what I mean? So you got that push and pull kind of thing. I don't know. I don't have the answer to it. I don't know if any of us do.
But I think it's kind of self-selecting. Not every client is the right client for every lawyer, and vice versa.
Mm-hmm.
So I think for the lawyer, the question is, can I do my job for this? Can I service this client in a way that I'm comfortable with and that I think is competent, under the, in the box that the client wants to put me in? If I can't do that, then I probably should say no thanks, which means Which is a real problem in today's world, where, there's huge competition, and we don't like to say no thank you to people. But there might be some where that is the right answer.
I feel compelled at this point, although I'm not sure the value of this, that one of the things that's happened is the blurring between your professional life and your private life.
Yeah.
And people do this all the time. You get, Jeff was talking about on a Friday night, getting a call from somebody. And I think people who are working 80 hours a week aren't working well. I think that it brings a malpractice risk to you. I think that being available all the time, and I am an offender, I read my emails all the time, and I respond all the time. And I'm retiring soon, and I'm really looking forward to not doing that.
He's going to suffer withdrawal.
Right.
Yeah.
But I do think it's important for people to think about that. I mean, it is a profession. You do have to respond to clients. It is very competitive now, but having some quality of life in some way, not to be working all the time and not to be responding all the time, if you can do it, is a thing people should think about. I don't know how you do that exactly, because the demands are tremendous, but it would be positive, I think, and probably reduce risk, stress, and you live a longer life. But.
And Ira, you mentioned you respond to them, and I think, Sally, you had something in your material about the quick responses. We feel compelled to respond, and yet maybe a more thoughtful, reasoned response later, or taking some time to respond, is better than the quick response. And I know I've heard Katya talk about it at these programs too. I think you have a saying, I can't remember what it is. It's much more clever than I could come up with.
It's Sally's. It's that these new communication forms allow you to get your mistakes out the door at the speed of light.
Well, how many people have people proofread their emails? Does anybody do that? I do.
I do too.
If I'm going to send out an important email in response to something, I have someone proofread it, just the way I would a memo. And I think that saved me quite a few errors, quite a few mistakes going out at the speed of light, which is accurate.
Do you do that with mail as well?
Yes, I do. Not everything, but things that I think really, I'm going to make an important statement of some kind.
The question was, does he do it with mail? And Ira's answer obviously was yes. Yes.
How discoverable are these emails?
Very.
Very, very.
Mostly completely. In a legal malpractice case, yes, the confidentiality, you have to defend yourself. They get to discover your file. It's very rare. Paul, do you want to, are there instances you could think of where people don't have to fess up and
Well, you're speaking.
yeah, I am.
Paul, you want to grab it? Thank you.
I think the context of what the email is being created in is important. Obviously, if you're being sued by a client, any emails to the client are going to be discoverable. You may want to use client emails to you as well. What's uncomfortable, I guess, is emails between your associates, partners in the same firm, where you may be dealing with things that the client never knew about. And there may be a point there where you don't have to disclose. If you're dealing with third parties, I think they're always disclosable. So, it's not a clear-cut thing. But, for instance, if Ira has somebody proofread his email and they give responses back saying, I think you're wrong about this, you may not want to produce that, or it may show that there's a dispute between the lawyers and the firm as to what the proper response should be. So, Ira, do you destroy the proofread email or the original email? Do you save those? Do we have to?
Sometimes I destroy them. I actually would still have them proofed, even with the risk, probably. But if basically I send them and say, I'd say most of the time our document destruction rules would have it destroyed within in a period of time. In 6 months, it would certainly be gone in an email of that sort. And you should have a rule on when your emails disappear and what that rule is, and you need to follow it, or else you can get in trouble for those kinds of things, for destroying, spoliation, and that sorts of things. So it would ultimately disappear.
We've been having this conversation at WILMIC for 30 years, weighing the costs and benefits of documenting things versus their discoverability should there be a malpractice claim. And you just need to find that balance, because I sure can't remember things. I can't remember which kid I named what at home. So I really can't remember what we talked about, what we agreed to, who's going to do what work still needs to be done. So I'm a documenter, and I think the benefit of that outweighs the risk of having that discovered. And I'm not downplaying that risk, but I think Ira's suggestion that for important communications that another set of eyes be part of that is still a very good suggestion, even with the risk of having that be discovered.
I will also say that I'm a CEO and I don't really do much claim stuff. So it's not that kind of stuff. So it's probably easier for me and much less risk.
And I would prefer to see a comment like that, where I think you're wrong about this analysis. I would prefer to see that take place in person, where there's a meeting or someone walks down the hall and says, I don't see it. And then you don't have that problem.
And that's a good idea, yeah.
And I do think that as we get more and more into this electronic communication stuff, people forget that they can do things like walk down the hall and talk to somebody, or forget that they can pick up the phone and actually call and have a conversation with someone, because we don't use those muscles as much anymore. And I'm always surprised. This isn't true anymore, but when in the olden days when we actually got phone books, and you'd be asking an assistant to write a letter to so-and-so, and they'd say, well, we can't find so-and-so's address, and you'd take the phone book off the shelf and open it up, and lo and behold, there's the address. And it never occurred to them to do that, because that's not what they were doing. I mean, that's not the standard operating procedure. So sometimes I think we forget the tools that we have available to us to make us better.
Right, and in the deposition, when they say, do you remember what you said? A very honest answer will be no, I have no clue. So, but the people can ask you about what you say as well as see
Yeah.
it. I mean, it's not foolproof, certainly.
Yeah, that happens.
Any other questions, comments, issues we have not raised yet that you'd like us to talk about? Okay, it's just about 10:15. We're going to take a break. I just want to mention that I neglected to say at the beginning, and that is, and many of you may already know this, this session, this entire program this morning has been approved for 3 ethics credits. So, and that's for the benefit of those on the web as well. And again, for those on the web, you can click the link to the materials to access those. We will have, in the next session, Shannon Winn, an attorney from Lake Geneva, and Joe McCarthy, our underwriter at WILMIC, will be up on the panel. And I'm hoping to hit several things, including unbundled legal services, which we mentioned briefly earlier, bartering, online services like LegalZoom, fee collections and billing, some of the issues with that, as well as fee agreements, which I know Sally just mentioned too. I want to flesh that out a little bit. And any other questions or topics that are on your mind, please feel free to raise those with us. Take advantage of our panelists this morning, who I know are delighted to talk about anything that's on your mind. So we'll take a 15-minute break. We will resume at 10:30.
Okay.
Thank you.
This side of the case isn't, because you.
All right, welcome back. Round two. In our second session, we have a couple of new panelists that I want to introduce to you. To my immediate right is Shannon Winn. You saw her bio in the materials. Shannon is a practitioner out of Lake Geneva and is very active at the bar. And Shannon is going to talk about a number of issues. And if you don't, maybe I'll just ask you anyway. But stuff like bartering, which I think is kind of interesting. I haven't been involved in many discussions about that, although I know it's out there. And then online services like LegalZoom and those sorts of things, and fee collections and billing, important too, as well as unbundled legal services. And so I'll get to Shannon in just a minute. And also, Joe McCarthy is now on the panel with us. Joe is Vice President of Underwriting at Wisconsin Lawyers Mutual. Joe previously handled claims in his previous professional life and also practiced for quite some time as well. So Joe will have some perspectives for us too. Joe was also incidentally a prison guard in Wisconsin for many years, so you can't really ruffle him at all. He'll stand pretty sturdy on you no matter what challenges you give him. So
I'm used to having things thrown at me, so go ahead.
so this is easy for him. All right. And again, I encourage all of you, if topics or issues come to mind, feel free to raise your hand and we'll get your question. Throw it out there. One of the benefits of doing these is to hear other people's perspectives and other ideas that maybe some of us hadn't thought of ourselves. So if you have a thought or a comment or you want to disagree, whatever it is, throw it out there. And that goes for all of you that are watching on the web too. Submit your questions and we'll talk about that stuff too. Because the one thing I don't want to happen is that you walk away from this saying, I wish they would have talked about this or that. So bring it up, we'll talk about it. All right, so Shannon Winn from Lake Geneva. Shannon, thanks for being here, and tell us, you've had a chance to listen now, and I know you have some ideas and things, so give us some of your thoughts.
Well, good morning, and I have some thoughts on BP and what BP has.
I'm looking for the tweets.
Yes. So
I'm looking for them.
I, like Sally, I'm going back to this.
Yes.
I sat on a panel about a month and a half ago with Tim Pierce, and this question arose directly. And it was even less so where they didn't state who the opponent was or who they were representing. They just simply said, I was successful today in court, got a judgment for X number of dollars. And Tim Pierce, very bright line, which we all know is very rare for Tim Pierce to have any bright lines, said, no.
I just assumed he was at the discipline.
He had stated, and you need informed consent. It's very clear, our confidentiality rules, because, with this judgment amount, it was pretty easy to look up this attorney won this judgment. You can go on CCAP. There's multiple ways that you could figure out what case that was connected to without having to do too much due diligence or internet research. And so he said, absolutely not. You need to talk to your client about that. So it's interesting how this attorney gets away with saying all these things about the cases that are going on, and perhaps the client is agreeing to allow him to tweet. I don't know.
I'm one of his clients, actually. I mean, the class at least. But it's a class action. There is no real client in a way.
But just so as a practice pointer here in Wisconsin, you absolutely need informed consent. At least that was the stance that was taken.
Shannon, did that go any further to say, is that advertising? Would that be advertising? So do you need to submit it to the?
Well, so it didn't go, but it arose in that context as to, how you're getting clients. Most of the time, that's the whole purpose of that tweet, right? Is so that you look like this amazing attorney who can get these amazing results, which gets to the point of, is this advertising misleading? Does this lead people to think that in every case you're going to have a result that ends up with this amount of money or this type of award or this final judgment? It's a very good question. I think it's a very fine line, and I think that's part of the reason that people use social media. So if you're not allowed to do this, it really cuts at the heart of, is social media even effective? Because other than being safe and saying maybe the law has changed with trust rules or something benign as to just a fact of law, not about a case, nobody really is going to read that or care or perhaps make any response. So you're limiting how effective you are with social media, I think, with this inability to say, hey, I'm a good attorney because I got this result. Now, if you can get your client to agree, you're okay. But there are, I think, a lot of circumstances where clients don't want that out there and won't allow you to do so. It's very interesting. And again, I don't know how many people are getting in trouble for it. I don't know how substantiated OLR feels that they're going to be going after this, but it is what it is. So that's my take on BP.
I looked at some of the discipline stuff before and there is discipline for people breaching confidentiality in blogging, in some tweeting, but mostly blogging or in answering Yelp sorts of things, takedown notices. So you can go over the line, but I do think that it'd be very hard to be noticed unless you're really pretty extreme.
Yeah.
I think there's literally billions of tweets, and who's going to monitor that? It'd be very hard to imagine.
Unless your client, who has not given permission, figures it out and turns you in, which is
Right.
appropriate too.
Yeah.
Yeah.
Yes?
Was Tim Pierce indicating that even if it's something that's publicly available, like say you represent someone in Wisconsin Supreme Court?
I'm going to quickly get you on mic here.
Say you represent someone in the Wisconsin Supreme Court and that decision is published, or even, you can link to the recorded oral argument in the Supreme Court argument. And if you just tweet it out, here's a link to the case I just won. To me, that is public information that's publicly available, and it doesn't seem like your client should be able to control whether or not you disseminate that.
It's different. I know that I don't know about Wisconsin, but I do know it's different from state to state. I know that in Philadelphia, they say no, it's still a confidence in some way or another, public or not. And in other states, I think in Oregon, you could do that, but I don't know about Wisconsin.
In Wisconsin, 1.6
Yes.
says if you learn about it in the context of delivering, a client services, you can't talk about it.
Well, what did you learn? You learned that you won?
Yeah. If it's
I
public
don't-
record is not the,
Right.
it's not the measuring stick. Used to be under the old rules, but it isn't now.
And that's the stance that Tim Pierce took. Even, for instance, you can find the information on CCAP perhaps, or something to that extent. He said, absolutely not. So, without informed consent.
Although I have to say, it seems hard to think that you could get into a lot of trouble for that, but it
Well, that's the other side of the spectrum, is how much attention is being paid to this. As you'd mentioned, there's so many tweets and there's so many people blogging and all of this out there that I'm not particularly sure how much of that's actually being enforced until you have a client who gets upset that that's out there. I think that probably would be the trigger point that would get you into some murky water, but until that point, it's probably not going to harm you.
Shannon, I just want to revisit unbundled legal services a little bit. I know you have some thoughts on that, otherwise known as, I guess, limited scope representation. It's still prevalent out there, right? I mean,
It is, especially in the fields that I work in. 2 or even perhaps 3 ways that I see it quite often is both in transactional or litigation. So in litigation purposes, I may be foreclosing on a home or a business or some sort of asset, and a person will hire an attorney just to file an answer. That's all that they do is file the answer, and then I have to go through summary judgment at that point, and there's no other follow-up by that attorney after they file the answer. And I recently, just this past Wednesday, spoke with a judge because I had a summary judgment hearing, which was a classic example of this. The attorney filed an answer. There was no reason to file an answer. There was nothing substantial in that answer. It was just to buy time. The attorney admitted that to me outside the doors before we went into court. We sat down, made our appearances, and the attorney simply said, we have no objection to the summary judgment. That was all that was done when he went back to the office. Well, I took a minute and I asked the judge, because I knew I was coming here talking about this, what's your opinion of that? And he said, I don't know why he came. I don't know why he should bill his client for that. And it's an interesting approach, because I know in another county there's a civil judge who takes a complete opposite stance to that, that says, I want you on the telephone or in person when you are on record for that client. I want you to make an appearance on behalf of your client, even if it is just to say, I have no objection to this motion. I think that perhaps in those cases you could try to save your client some money by writing a letter saying we have no objection and I will not be appearing. Other times, if they'll allow a telephone appearance, that obviously would save your client some money. But I personally am very troubled by the fact that there are these flat fees that people charge, $500, $400, $800, whatever the case may be, to file an answer in these actions and never show up again. I have to talk to these attorneys if I need to get information, of course, because now they're a represented party, and they won't respond because they haven't been paid to respond to me, which creates more problems, of course, when it comes to, I think, ethical implications of representing your client. And
Do they withdraw ever?
No, I haven't seen one yet. I wish they would, to be honest with you. I do.
I'm sure you guys wish they would too.
Well, eventually, we're gonna have them.
Yeah, and it's really prevalent. I really,
Well, let me just weigh in
Sure.
with one exciting new event that's happened in the state of Wisconsin, and that is that there are changes to Supreme Court rules that have been approved to go into effect on January 1 that deal with limited scope engagements. And they require, I haven't studied them in great detail, but they sort of make my heart beat a little faster as a claims person. I think they've got some really good things about them because they recognize the status of limited scope engagements. And then I think there are some really difficult things because they require that these limited scope engagements be spelled out, if it's a court case, be provided to the court and served on the other party, so that so what the lawyer is responsible for doing is described in this notice document that's required. And then when the lawyer is done doing what the lawyer is supposed to do, the lawyer is supposed to serve another notice document that says, I'm done now. And until that time, the lawyer on the other side of the transaction, the creditor lawyer in this case, would be sending notices both to the debtor and to the debtor's limited scope lawyer. But we're going to have more paperwork and more documentation, and if we miss those things, see, part of my observation after all the years that I've done claims work is that lawyers lots of times do limited scope stuff. You're only hired to do a portion of a case. It may not be spelled out that way, but in everybody's heads, you might not say, oh, I'm doing a limited scope engagement. You say, I was hired to do X, and I do X. And it may, in fact, be that we're going to have to learn what a limited scope engagement is in different ways than we've recognized it before and recognized it more formally than we have before. I think that's going to be a learning process. There are some steps here. But the rules are out there, and I commend them to you. It's worth looking at if you think this could affect your practice at all.
well, and to follow up on that, I think most people hire somebody limited scope because they have modest means or they don't have the means to afford representation through the entire case. And it sounds like these rules with all this service and all this paperwork that will be added would additionally make that limited scope more expensive. So I think that it may create a problem in the fact that people are not going to be able to afford even a limited scope arrangement anymore.
This may be a be careful what you wish for.
Right,
situation.
exactly, which then gets me to another topic on my list, which is legal Zoom and these legal services where there is no attorney involved, that people just go online and they create wills or other documents themselves because of the fact that legal services are getting more expensive or because they don't.
Shannon, I'm sorry to interrupt
Sure.
you before you move on. Katya, did you have a question?
Yeah, well, I'm getting a lot of questions from the web, and they're going back in time to topics that you were on a little while ago. So one is.
Sure.
Sorry. Which Supreme Court rule does Tim Pierce base his opinion that an attorney cannot communicate about the outcome of a jury trial? A verdict is not confidential. What if a newspaper or TV reporter who's covered the trial asks the attorney a question?
It goes back to 1.6, the confidentiality.
Thank you.
That's what he used.
All right, and then there was a question, oh, that's not a question. The question was, have you tried, I'm not repeating it.
Comment removed by narrator.
No, it's totally complimentary.
Oh, well, let's hear it.
I'm not saying I agree with it.
The question was, have you tried claiming the defense is frivolous and subject to sanctions? But I don't know what it refers to, do you?
It
The
would
answer.
probably.
The answer, right?
Yeah, probably the answer to the foreclosure case. And I will tell you that in most of my cases, the creditor doesn't want to deal with that, doesn't want to end up paying me to make this claim just in the end to get their judgment that never gets paid on anyway. So they're looking at their pros and cons of that representation too as to what they're paying me. So it probably could be done. It depends on, of course, what judge you're in front of, because like I said, the judge I was in front of on Wednesday wouldn't have heard that. He thought it was perfectly fine what had happened. So I think you need to know who you're in front of as well, perhaps, as to their opinion on the matter. And there are some judges who get very upset and will have their clerk call that attorney going, where in the world are you? Why aren't you here? You have a matter on the calendar that's being called right now, and the plaintiff's attorney is here. Why are you not here? You're the attorney on record. So I think in cases where you have a judge like that, if you have a willing and able client, you probably could bring a claim as such.
All right. Yes, Katya.
I have another request from a listener that you move the microphones closer to your mouths and try harder to speak into them.
Done.
Done, thank you. And another question says, if I get a completely unsolicited new client referral email requesting legal services that I don't even perform from one of those purported lawyer referral sites that may or may not even be real, do I have any obligation to respond that I'm not taking on the supposed client, knowing, of course, that any reply will almost surely only generate more such spam?
And I think the answer to that is you do not. If it's totally unsolicited, you haven't sort of put yourself on that website for some reason or another, then you have no obligation at that point. And,
So
it
you
wouldn't-
could-
and even no matter what information they gave you, it wouldn't create a conflict either.
I think that's true. I also think it's better if your email, well, if it's just an email to you, you probably wouldn't have any kind of a disclaimer. But if it's a website, they've come in through a website somehow, your website can have a disclaimer that says we don't create an attorney-client relationship in this way. And that also has been called out in Wisconsin as a helpful tactic.
And the other disclaimer you should put on there if you're going to do that, get referrals, is that the communications aren't confidential.
Yeah.
So they're not confidential, and it doesn't create an attorney-client privilege. And both of those things need to be in there if you're going to seek those kinds of clients.
All caught up?
Yes.
Okay, thank you,
Thank
Katya.
you.
It looked like you had your hands full there for a while, so. But web people, keep them coming. Not that I want to overwhelm Katya, but we'll get to those as soon as we can. So, Shannon, you were...
Legal Zoom.
Legal Zoom, yes. And
Nobody in
other-
this room, I'm sure, likes legal Zoom. I don't know many people, attorneys, or even clients that have had that great of an experience with one of these providers. They are gaining steam. They are allowed, legal Zoom in particular. There was just an ABA article that went out this past week. 41 states allow them to perform services in their states. 8 states have had lawsuits. The unauthorized practice of law, brought against LegalZoom. All of them have failed. So it seems as if less people are bringing these types of lawsuits against services like this now because of these defeats.
And they're here to stay.
And they're here to stay. That's exactly it. So I think what that boils down to is you have to make yourself a human. So make sure your customer service is top-notch. Make sure that you have services that are specific to that client, that you get to know your client in some sort of personal way, even if it's just to say, I know your kid plays basketball, and to ask them once in a while, how's the season going? Something to that effect that a computer and a screen and you filling in the blanks does not do. Now, this isn't going to work, of course, for people who are looking for the cheapest alternative, or I'm also a practitioner. I prepare bankruptcies, and I deal with bankruptcy petition preparers as my competitors, of course, and they're much cheaper than I am. And that's somebody who's not supposed to be giving legal advice, or realtors drafting offers who are not supposed to be giving legal advice. These are all people that we're in competition with, including LegalZoom, that we have to show that our services have value. And that goes to communication too, and how you deal with if you accept text messages or not, or if you accept that you will respond to an email within an hour of receiving that email, or take a telephone call at 11 o'clock on a Friday night. I think that all of those things are decisions that we have to make and set the client expectations right off the bat, so they don't feel as if you were demonstrating right away that you're there at their beck and call, and then you aren't later on. So if you set the expectation that you'll answer those telephone calls late at night or at odd hours, or you'll answer emails throughout the weekend, I think you have to keep your services continuing in that fashion. Otherwise, you will lead yourself to having bad reviews on Yelp or some other things too. But I at the other fold is you have to make yourself more available than a computer where you're just filling in blanks. You have to show that you have more value than this computer program does.
I was speaking to someone at the break, and they put those kind of communication issues into their engagement letter. Mm-hmm. That I won't respond to this, I will respond to that. You can't use a cell phone, or you can, whatever they are, you could put that in your engagement letter.
That was one of the questions I had from a web viewer, is whether it was a good idea to put whatever your communication policy is in your engagement letter. And I think that it is.
I would put it in there, but I would always put in a fail-safe that if something's really horrible, you can call me or get in touch with me, and I will respond. But I think it's a good idea in general.
And Ira, do you think it's good to say in there, I do not use texting, or whatever your policy is, from the question that was earlier on the first panel?
I do, but I would justify it in terms of the protections that it provides the client, not your convenience.
Oh, absolutely. I think
So-
that's really important. I think Shannon's right. You need to make this personal between you and the client somehow, to establish a relationship there, and to make them understand that this isn't, this is not like going to the web to contact a plumber. This is a personal legal matter, and it requires treatment that's very different from other commercial transactions that they're entering into on the internet.
Any other questions, comments about that? Yes, sir.
I'm just wondering whether anyone on the panel has run into a situation. I'm seeing it more often where a client, maybe not a great client, but someone that you've had some dealings in the past, will send you a document, like a non-disclosure agreement or something, and say, I pulled this off of the web. Can you take a quick look at this and let me know if it's okay? And so they're asking you to basically bless some document that they've pulled off the web, and I've just found it to be difficult to tell them, hey, look, I'm not going to bless someone else's work product, and I have my own form that I'm familiar with and I use, and that, and if you want me to do that, I'll do that. Let's talk about it. But they really get angry that, this I found this, and, there's comments that this is a good form. And I've just had trouble dealing with some people, and actually they've gone elsewhere because I refused to just bless a document that someone else prepared.
Thank you, I appreciate that, because I hear about those things. Yeah.
I talk to lawyers every day, all day, about stuff that's just going on out there. I've had that conversation with lawyers, particularly in the course of drafting wills. They'll have somebody send them a will that they got from some site and ask them to bless it. Most of the lawyers out there that I've talked to say, no, I don't want any part of it. For one reason, they realize, I don't want to bless somebody else's work. The other piece of it is, I'm losing clients because of these websites as well. But, you know, to some extent, we're our own worst enemy. There are websites out there. Last fall, we did a seminar, we had a meeting in Madison of all the companies like us. And one of the things that we looked at were the different websites that were out there. I actually found a website where the party writes in and says, I just got a drunk driving ticket in this county and wondering who can help me. Lawyers literally responded and bid, sort of like name that tune. I can name that song in 2 notes. I can do this work for X amount of dollars. And the cheapest lawyer ostensibly got the work. So we're kicking ourselves in the other foot. You know?
To the extent that those sort of services or arrangements cross jurisdictional lines, and I think some of them do, you can get in trouble for that. You can unauthorized practice in another state. So I think you need to be careful about that. You need to be careful about what you're really offering those people, since more than likely there's going to be more to, many times there'll be more to the issue than what you've said you will do for a certain amount. And I think that those things are another example of social media truncating your normal relationship in a way that it's dangerous for lawyers without examining those things, making sure that they say, I can only do this in this jurisdiction and this is what I'm going to be doing.
I was talking to a lawyer about this at a state bar program a while back, and he actually took the opposite view. He said he embraces and likes that LegalZoom and other services are out there, because he said, I get all kinds of business from these guys because they screw it up so bad. I get so many clients who come in and I need to clean it up and fix it, and you know. So he was quite glee about it, you know. So I guess it can work both ways. I mean, no matter how you look at it, I guess, as Shannon said, these services are here to stay. So we have to figure out, you know, how to work within.
But aren't there some situations where you should review those documents? 'Cause I've had clients come in with leases they've pulled offline that are supposedly valid in all 50 states, and they violate all the rules in Wisconsin.
Yeah, that goes to, I think, Ira, your point about crossing jurisdictional lines.
Well, there's partly that, but I think that you have every right to charge to do that, and that it's not a quick, oh yeah, this is fine, it's signing off. We had a fairly large claim where LegalZoom had incorporated some company or another, and they had a lawyer check it out, look at it, look for the tax consequences of what had been done. But the lawyer looked at the LegalZoom stuff and not for the whole basis of the corporation and what they were doing and what tax law applied, and just said, oh, this looks okay. And it was a significant claim for that. But had they really taken the time to look at the underlying matter, they would have done it differently. Does anyone know what LegalZoom's liability protection is? Just out of curiosity? I don't.
I'm guessing there is none.
Yeah.
They're saying they are not giving legal advice.
Well, they're still doing something.
Yeah, they are doing.
They claim that all they do is proofread off of what people put in boxes and check for consistency. That's it. That's what their claim is. I'm not arguing that's what they do. I'm just saying that's how they get out of this, is through proofreading apparently, and that's about it.
Anyone else? Katya, nothing? Okay. All right. Let's talk bartering. Shannon, I'm interested in this one.
Sure.
Is it out there? This happens?
Apparently it's out there. I don't do it myself, but I teach a class at Marquette, and this was brought to my attention by one of my students, that there are services and sort of exchanges. I don't know how many people are familiar with Bitcoin, but it's basically these bartering services allow you to perform for a person's services, get this fake currency. In exchange, you can use that fake currency to have a painter come out and paint your house, or a plumber come out and fix your toilet. You know, whatever you can use those coins for that is available on this site. And I find many parts of that troubling. First and foremost, I wonder how many trust rules kick in with that, because of the fact that we are obligated to keep funds in trust accounts until we have earned them, unless you go through the steps to avoid that. And I don't know how fake currency works, whether fake currency applies under our trust rules, because it's technically not dollars and cents, but it is worth something. So I brought that up to the attention of Tim Pierce, and I don't really have an answer as of yet. I don't know how often he gets that question or how much he's delved into it. In addition, the other thing with bartering too is there is rules regarding business transactions with our clients. So we need to inform the clients in writing of what the terms of the transactions are. You need to inform them that they can seek an attorney and should seek an attorney to review this to make sure that it's fair and make sure that it's in a manner that the client understands and that it's not related directly to your matter. So you're not creating a conflict between you and your client on whatever the case may be. So there is ways to get services in exchange for, you know, your services to the client, meaning you don't have to exchange money, but there are paperwork and rules that need to be followed in order to do that.
I want to highlight that the rule that Shannon's talking about, this 20:1.8, a lawyer entering into a business transaction with a client. We see in claims lots and lots of instances where that in fact happens, where it's the lawyer's personal business dealings. You know, lawyer selling a property, lawyer selling a business, lawyer going into a business with a client and so on. All of those 1.8 rules must be followed, or there are ethical issues with doing that, even if it's your own personal stuff. So, because you have this lovely law license, you've got responsibilities to deal with those issues in that way too. And there are lots of times where the lawyer's pulled up short too late and hasn't made those disclosures appropriately, hasn't gotten the appropriate written consent in those matters. So please be aware of that, how it affects what you do. Anybody?
Questions, comments on that? Yes. Wait for the microphone, if you would.
Please.
Right down here.
We have one in the back also.
What's your opinion if you have a client who, for example, will come in and paint your office for you in exchange for defending an OWI ticket? So that kind of bartering of services. What's your opinion about that?
Well, obviously it doesn't relate to the OWI, so you're not worried necessarily about it creating a conflict that way by entering into a business agreement directly related to the litigation. So you're okay there, but it still follows the rules as to you have to make sure that painting your office equates to what you would charge them for defending them. Meaning, if it would charge you or cost you, maybe $3,000 to paint your office, but defending this, usually you charge a $500 flat fee, I think that's not reasonable. So I think you have to do those sorts of calculations too. Tell them that they can seek an attorney and put it in writing that they have the ability and should seek an attorney to see if this agreement is fair. You have to follow that. And again, make sure that they understand exactly the terms of what is going to happen, all in writing, of course. So.
Yeah, it should be a written agreement, absolutely. Yeah, it's a lot to, and of course, it's a taxable transaction, so please understand that.
Sally, you need to get closer to your microphone.
Okay. All right. Will do.
Yeah, I wanted to say, isn't the most obvious problem tax evasion here? I mean, how many people that barter report it to Uncle Sam?
Right.
Yeah.
Right.
Probably next to none, I would guess. I mean, yeah.
So, yeah.
I want to visit another topic, and maybe we don't have to spend much time on this, but I'm just curious. It was on our list that we have not gotten to today, and that is Skyping or teleconferencing. And Jeff, I think it was on your list because I think you do some of this with maybe more of your international clients. the Skyping and teleconferencing. Do any of you do that with clients nowadays? Is that still a rare thing, or you do? It is. Okay. Panelists, what do you think? Issues to this, or good idea? I mean, it's part of our technological world now, so.
Well, it's a way to incorporate, of course, somewhat of that body language, because you can see the person's facial expressions and things of that nature, so it's probably adding an element other than just having them on the telephone.
I think that who's there is important.
Yeah.
Especially on the other end, not so much your end, because everyone's going to be working and no privilege there, but who's there, who's in the room when you're talking to someone else about a claim or a case, a client. I think that's probably important as well.
Okay.
You can easily waive it.
Yes, Katya.
Going back one topic, I have a question from the web. When the bar considers these reduced fee, reduced service arrangements, to what degree is the fact that many potential consumers with legal needs will go without service unless these types of arrangements are utilized? What's the proper balance in leaving people unrepresented?
Good question. Panelists, what do you think?
I mean, I agree. That's exactly why I brought up the limited scope proposed rules, because I think that adds probably a substantial cost to limited scope representation. And I think whenever you add costs to the limited scope representation, you're going to lose people that's all they could afford to begin with. They wish they could have the representation from A to Z, but they're not able to afford it, so they pick the most important part and have an attorney represent them with that. With this limited scope or the proposed rules, I think that they may not be able to even afford that anymore. So I agree completely with the comment. I don't have an answer, but I think maybe that's where you get into if the forms are out there, turning to LegalZoom or some of the cheaper alternatives. So you're right that they may be representing themselves in the end, I think.
My reaction to part of that is that a party hires a lawyer to answer a lawsuit. And that's all they can afford, so they feel like, geez, I need to answer this, when in reality, all they're doing is buying time and delaying the process. And frankly, causing your client a higher cost.
Correct.
Because your reaction to an answer and filing a summary judgment motion is higher and more expensive than
Yes.
simply having a default out there. So it seems to me that it's a good idea, or, it feels good that people are being able to answer a lawsuit and have this representation, but in the long run, is that really a good thing? Because it's costing your client more, it's delaying the process to some extent, and it's putting these lawyers that are doing that, I think, in some risk in what they're doing. You have an obligation to not just your client, but the court, when you file a pleading and you're there as the lawyer of record. I don't know. I have mixed feelings about that. I don't want anyone to go unrepresented. I think they should have a fair voice and all that, but some of it, I think, counterbalances what we really need and what we really want.
On the other hand, I think it's perfectly okay for someone to file an answer, withdraw, and have that person go pro se if they want to. I mean, I don't think that it's all one thing all the time, so.
This is an adversary job that we do. I mean, that's where we are, and that's what kind of life we have. So there are competing positions in almost every instance. And somehow you got to balance all of that with what I'm comfortable with morally and ethically in my own mind, because I don't have to take every client that comes to me just, I can choose to starve if I want to starve. But you don't have to take everybody who comes in the pike. You are responsible for compliance with the rules of professional conduct, and there's room for discussion in some of those rules, at least until you get to an investigation stage, at which point you may lose some of that ability. But I think that it's incumbent upon all of us to be thoughtful and careful about what we do and what we want to do and how we accomplish tasks and representation for our clients. And in that process, one of the things we consider is, do we want this person for a client or not? Do we want this company for a client or not? One of the things, let me wind this back to some of the earlier topics that we were talking about. Should lawyers be Googling their prospective clients as a matter of course today? There's information available for people. If you don't know these people, should you be looking them up and figuring out if they're real and if what they're telling you is probably okay and what other kinds of experience they have had? Should you CCAP them? Is that okay? Yeah.
You could argue, couldn't you, Sally, that not doing that could be considered malpractice?
Oh, I don't know if not doing
Not
that
for
is
you.
malpractice, but I think it's could be very unwise. I mean, there are simple ways to vet someone's credibility today, or at least to begin to vet somebody's credibility today. Shouldn't we be using those?
I think you should. I do think also that it might be malpractice. And to Tom's question, if you don't look at a social, I said this before, if you don't look at a social profile of an adversary or someone who's on the other side of a deal, I do think that you should do that. And it's probably malpractice if you don't tell people, your clients who are on Facebook, are involved in litigation or something, or a matter of some kind, not to post about it. And there's a number of cases where people say incredibly hostile, bad things that essentially sabotage their claims by posting on Facebook, you know, my lawyer's going to do this, all sorts of things that people have done. There's one case of a doctor in the course of a trial blogging under a pseudonym about the trial as it went forward. And on cross-examination, somebody figured it out, and they asked him, are you Flea, which was the name he was using, and the case settled soon after, obviously. But people do that, and they do that on Facebook, and they feel that they're entitled to do that, and not telling your clients how to handle those situations and not to talk about these things, I think would be malpractice, too.
And maybe not checking their sites, your own client sites,
Right,
not
no,
just
it's
the
your
other
own client
side.
that you need to deal with as well.
Sally, you mentioned earlier, you said, you made the comment, I have a right to starve if I want to. In other words, turning away business.
Yeah.
Is that not part of what drives this a little bit in terms of client selection, is that we have, you know, it's a tough economy, a tough competition, as you mentioned. A lot of lawyers, especially younger ones starting out, who it's hard for them to turn business away and see it walk out the door. So they end up taking cases, maybe some that they shouldn't. Isn't that part of this?
I think that's absolutely true. I remember years ago, Katya and I were at a bar convention, we were manning the WILMIC booth, and two young lawyers came over and they said, well, here's what we tell clients now. You remember this? They said, well, we're young, we're just out of school, we don't have much experience with anything, we aren't going to charge you much, and we're going to work really hard. Is it okay if we tell our clients that? And we were both choking, you know, it's like, you're going to tell them I'm young and I'm dumb and I don't know what you're doing, but I'm not going to charge you very much, so it's all going to be fine. It's like, that's not the standard of care for a lawyer. So, yeah.
It's quite a sales pitch.
Right. I don't know how far they got with that, but anyway.
That's probably when LegalZoom started.
The idea for LegalZoom was right there. Anyway.
What about blogging? I don't know that we've talked too much about this. I guess it kind of ties in with the social media stuff. But I know there are a lot of lawyers out there who are blogging, some of which I follow just sort of in a voyeuristic way to keep track of what's going on out there. And there's one in particular, he's not in Wisconsin actually, he's in Seattle, and he blogs every day, and, you know, on various legal issues. It strikes me, his blog strikes me as very commercial. In other words, I think he does it more to make a name and get business, which, you know, I guess there's nothing wrong with that. And I guess, Ira, I'll start with you on this. Is there something about blogging where you're doing it as a marketing tool more than, you know, discussing legal issues where you can get into some...
I think that a lot of people blog just for that, solely for that purpose, because other lawyers will read it, they will see that this person claims to have an expertise in and may well have an expertise in a particular area, and refer people to them. And I think that's very common. I think you do run into the same confidentiality issues in spades when you do that, if you talk about claims or cases or individual people, things you've done, whether something's public or not, and all those issues when you're blogging. I think you have to be very careful about it. But obviously, it's pretty mainstream. I think that it's a legitimate thing to do if you pay attention to the confidentiality rules and disclosure rules.
I think you have to be careful about how you do it. Not just that. I think there's I just discovered a lawyer in Wisconsin. He's a kind of repeat claimants lawyer. So I run into this lawyer with some frequency and just found the blog that he's writing. By golly, I don't understand anything on that blog. I mean, the writing is so dense and so difficult to decipher that his clients have got to, they either are not reading his blog or they're seeing that he writes a lot and they're impressed by that. But I don't understand what he's saying. So I'm not sure how good a tool that is for getting clients. Maybe just the fact that it's there is enough. I don't know.
Joe, when you assess risk, you can look at what lawyers are doing out on the internet, right?
Right. Yeah, and I do it every day. So for those of you who aren't out, if you think you're not out there, you are. There are different sites that identify every lawyer out there and talk about them to some extent. So, but I look at websites and blogs and all sorts of areas. And to some extent, the marketing side of it, the blogging that lawyers do, isn't very much different than what you see on some firms' websites, where they talk about their successes and how many, I just took this case to the Supreme Court and was successful, and how many $1 million verdicts we've had, or how many $1 million settlements we've had, and how well they've done against big corporations, those sorts of things. But the blogging goes a little bit further, it seems, with some. I've seen some blogs where the lawyer's out there saying, if you've ever had an incident with this product or this place or this company, come to me, I can help you. And then you'll see a string of back and forth between people and the lawyer talking about, well, here's my situation, how does that apply? And it goes back and forth. And comments from some of the people on there, keep in mind that the corporation that you're talking about looks at this blog every day, so the amount of communication that's out there it seems to have expanded exponentially from what it was a couple of years ago, and that none of it's confidential anymore. Everyone's looking at it, not just the lawyer, but all the people who think they might have a case against this company and the company. So it seems that it's gone beyond just advertising and puffing about how good I am, to the point where it's like you're almost giving legal advice and creating client relationships.
This is a blog, it was in Illinois, and for which the person was disciplined, and I would think it was apocryphal, but for the fact it came out of the discipline stuff. 127409, the client's identification number. This stupid kid is taking the rap for his drug detailing dirtbag of an older brother because he's no snitch. I managed to talk the prosecutor into treatment and deferred prosecution, since we both know how the older brother from prior dealings involves guns and drugs. My client is college. And then it says, Dennis, the diabetic whose case I mentioned on Wednesday's post, this is the next day's post, did drop his order after his guest appearance Tuesday and before allegedly going to the ER, which, guess what? It was positive for cocaine. He was standing there in court stone, right in front of the judge, probation officer, prosecutor, and defense attorney, swearing he was clean and claiming ignorance as to why his blood sugar wasn't being managed well. Well, people don't know the rules, I guess is the conclusion. But I'd be careful blogging.
Wow. You really do monitor this stuff, don't you?
They need better advice than be careful.
Well, it's entertaining in its way.
I'll
but
say. Wow. Any other questions, comments about that? All right. Yeah.
Don't do that.
Don't do
please.
that, right.
Yeah.
Right.
I mentioned earlier that don't get in, if your client's emailing you 12 times a day, please don't try to answer 12 times a day. It just doesn't work very well. I say that, and then I have to tell you that there was one email exchange that found its way into my files where it took, I am not kidding, 13 emails. With the lawyer saying, you know, you just have been so awful, I can't work for you anymore, I quit, and the client writing back, no, you haven't quit, I'm firing you. And it took 13 back and forths. Now, somebody needed to be a grown-up a little sooner than they were. In that case, it really wasn't worth anybody's time to spend 13 emails back and forth to be fired or to be quitting. But, you know, what's important? How do we cope with it?
Yeah. All right, let's talk about fee agreements, fee collections, billing. I'm going to get to you in a minute, Sally. I'm going to start with Shannon. Sally, you can talk, I know, about claims that arise from or come from fee disputes and so forth. But Shannon, I know you have some thoughts on fee collections and billing.
I was sitting again on another panel regarding fees, and it came to my attention, one attorney had stated that they send out a letter about 6 months before the end of the year stating this is the amount that you have not paid for my services or whatever is overdue. If you don't pay me by X date, I'm going to send you a 1099. Cancellation of debt, which then, of course, they have to report on their taxes. And apparently, this has been very successful because people are very afraid of adding income, and the IRS is a big scary thing out there, and they just don't want to deal with it. Now, of course, you have to follow through if you're going to say this, because if you threaten this and then don't follow through, you've got other problems. But it's interesting in the fact that when it was brought up, there was no real answer as to why it couldn't be done. It didn't seem as if any rule had been broken. You're following the IRS regulations, and it was effective. So I don't know how many people are doing this. I don't know if it's going to gain any steam or not, but it really is an interesting concept regarding collecting fees. I myself have not done it. Disclaimer out there. But I do think it's something worth thinking about and noting, I guess. And maybe we'll get some, you know, back and forth opinion, because I have brought it up to Sally and Joe before.
I mean, it sounds sort of okay in a way, but if it's your sole reason to embarrass that person or coerce that person into paying, I'm not sure that's a breach of some fiduciary duty to your client. And that there are disciplinary rules to talk about. You really just can't go out and do something to embarrass somebody. And,
right.
And I wonder whether, if your real intention is just to collect the money, maybe you can assail it in some way, but maybe not. I don't know.
But I mean, a past due invoice could be embarrassing to somebody too. I mean,
Sending
if
to
you're.
IRS is more than a past due invoice.
True, I agree.
Yeah. I don't know.
Is that the alternative strategy to actual suing for fees?
Well, it seems to be, you know, an alternative strategy, certainly yes to suing, or an alternative to getting a collection agency. That was something that was brought up too, that seemed to have some effectiveness.
Yeah.
People would hire these collection agencies and of course have to pay them a fee on what they collect.
Well, certainly from a malpractice carrier's point of view, the worst thing you could do is sue your client for fees.
Absolutely,
So
absolutely.
go do these other things.
Well, there you go, there you go.
Is that my segue?
Yes.
Really, though, isn't it a bad business practice when you get to the point where you have to demand your fees?
Of course.
Yeah.
I see that, especially in large firms where associates will spend half their time collecting fees from partners. And don't you really have to sit back and say, if I'm collecting fees, I'm not doing this right. You know, something is wrong with the way I'm running my business. Or am I just in an idyllic world here?
Yeah. Absolutely, that's right.
Yeah.
You know, and it is, you all have heard the stories about the counterclaims for malpractice that come, you know, the best defense is an offense, and that does happen, and we see a number of those kinds of claims. Obviously, I'm not telling you anything you don't know. The most important thing you do is client selection. Who are you going to work for in the first place? Do they have the wherewithal to pay you, and will they value your services? those are important questions very upfront. Getting the advance fee and doing what you're supposed to do with that money is a really important thing for lawyers to do. Are people willing to invest in their case and in you when they need you the most, upfront, when you're being hired, at that time, now? And if they're not willing to do that, that's probably some powerful information for you as a lawyer about what you want to do with this client. I think pro bono work is wonderful, but I think you should do it knowingly, not unknowingly. So, and I remember one legal malpractice claim that we had where the lawyer had sued for fees. The client, after several years, the client's response was, well, there's malpractice here. So I'm talking to the plaintiff's lawyer years later, and I said, look, the lawyer billed your guy, never got a complaint about any legal work, billed him repeatedly for more than 2 years, and your guy never once said he wasn't happy with the work that had been done in this case. And what the plaintiff's lawyer said was, well, he was objecting subliminally. And you all know what that means. So when your client is objecting subliminally, I think that requires a response from a lawyer, particularly in an ongoing representation. It means the lawyer, I think the lawyer who did the work, not the associate, needs to call the client and say, is there something happening here that's not okay? Can you pay the bill? Why aren't you paying the bill? What's the deal here? It took me a while in my own practice all those years ago to figure that out, but once I did, I found out an amazingly magical thing, and that was one phone call from me. The first time that happened meant there were never any future collection fees with that client. It was a powerful, powerful tool to use, because they have to tell you to your face that it's working or it's not working for me, and this is why I'm paying or this is why I'm not paying, because you've asked them that question and you have a position of trust with them. That's worthwhile.
I wrote an article about this topic probably a couple years ago, and I interviewed several lawyers for the article. Several of them said to me that they would never sue for fees. They won't do it. I think going to your point, they said if that's the position they would find themselves, then they have to examine their entire practice and what it is they're doing wrong or not.
And I would agree with you. I have a solo practice, and I have maybe a couple clients who owe me fees, and really I just look at myself and say, if I was dumb enough to take these people as clients, then I'm not going to spend the time collecting, and shame on me, and I'll do it better next time. Because you don't have to take everybody that comes through the door. And if they, like you say, if they can't meet your fee expectations, the door is that way.
And I guess even if you get a judgment, that doesn't mean you're going to get your money.
Absolutely, and you spend more time fiddling around with this stuff than it's worth, and you can be doing work for other clients who pay their bills.
Yeah. On the other hand, several attorneys also that I interviewed for that article, they took a different approach, saying, yeah, I try to avoid those situations. I don't sue for fees often, but sometimes I have, because I did the work. I did it, in my opinion, as well as could be done, and I deserve to be paid just like, my plumber or my doctor or whoever. And I guess that's a reasonable argument. But I guess you all have to weigh that, do that balancing test. Is it really worth pursuing those fees or not? And Sally, as you say, you see these come across your desk.
And I would never say never sue for fees. That's not our decision to make. It's your business decision to make.
Right.
And I think there probably are some clients who should be sued for fees. But I think it should be done really thoughtfully, and I think you should go through the checklist. If the person can't pay anyway, why bother? If it's not enough money, so that by the time you're done screwing around with it, you aren't really going to, is the principle of the thing should be rarely the driver for this kind of an action on a lawyer's part. Is your file squeaky clean, and are you willing to put it in front of a court because you might have to? Think about those things in advance of that.
We tell lawyers who want to contemplating suing their client that they should take that file and they should have another lawyer look at it and say, is this bulletproof? And if it's not, they shouldn't do it. They don't do that, but we tell them to.
You're doing your job, Ira.
Yeah.
And Joe, when you're evaluating applications or potential insureds, is suing for fees something you look at?
It is in certain times. There are carriers out there that if you sue for fees, you won't be insured by them. They will drop you like a hot rock. They want nothing to do with it because of the counterclaim that's eventually coming. We take a little different view of it. As Sally said, as long as you're being diligent about what you're doing, and if you would sue that person as you would anyone else out there, if it's a legitimate claim to make, then, we try to evaluate it on a case-by-case basis. But there are times I'll look at lawyers on CCAP, and there's quite a list of claims out there being made by that lawyer. It gives me pause. It makes me wonder if they're running a good business, if they're making good client selections, because it's a reflection of not just that piece of it, but your client selection might be questionable to begin with. So we do look at it, and it does impact at least my reaction to those folks that we insure, and potentially sometimes we don't insure someone because of some of that information that's out there.
Okay. Any questions, comments? Yes, Kathy.
I have one from the web. This is going back to the discussion on lawyer blogs. The question is there any meaningful distinction between a blog and a law firm puff piece explaining new developments in the law with particular attention to the case our firm just happened to win?
From my perspective, the stuff that's put on a website is one directional. It's going out. There's not give and take between another person or maybe a group of people out there, and that's the difference I see in the blogging and what I call puffing, but or putting out there how good you really are. So that's the difference that I see, is the stuff on the website is to be read and consumed as opposed to debated between a group of people and the lawyer or the law firm.
I think they're pretty much functionally the same, though. I mean, that would be my take on it. And a lot of law firms have people who blog as part of their business development, and they encourage people to do that. And so I don't see how that's really very different. Yeah.
Okay. All right. We've been talking about the demands and pressures that lawyers are feeling from clients. I guess, Sally, let me start with you on this. I just want to go back to it a little bit. How you mentioned in part of your materials the idea of trying to set and control these pressures or expectations from clients. How does a lawyer set and control these expectations?
Okay. I think it's different, obviously, if you've got somebody sitting across the desk from you, or if you're just online trying to create a relationship online. We've already talked about a whole bunch of these things, but to summarize that more or less, I think that you need to be clear in your mind about how you want to and can efficiently and effectively handle a client's matter. Then that needs to be communicated to the client in a meaningful way. An engagement letter, I really like the idea of putting, this is how I communicate with my clients, so that you control that aspect of the transaction if that's at all possible. I think that's the best situation. I think it's part of what you consider when you consider intake on a client case in the first instance. How are we going to communicate effectively for this matter? So that, and putting it in your retainer agreement, and then anybody here who's a parent will understand this comment, being consistent with how you enforce that. So if in fact you tell your clients, I'm not going to tweet, or I'm not going to do text, I don't text with my clients, and you start doing that because of a specific issue or problem that comes up, you have lost your power in this case, and you're sunk. So consistency is important. I appreciate Jeff's comment about telling his clients that if it's something really important, they can call him at 11 o'clock on Friday night. But boy, if I had a client who was doing that at 11 o'clock every Friday night, I would want to take some action about that. That's not appropriate. And people, people's social monitors have changed so much. What our governors, what our speed limit really is, and how we deal with and talk with other people. They're kind of off the charts, and I think you need to put that into the relationships that you have with your clients. Yeah.
Shannon, how do you control expectations?
I actually have it in my agreement with the client. It doesn't necessarily, like Sally said, always work because people don't tend to remember what initially you had said, and later on down the road they want responses. I certainly try to get to everything email-wise or telephone call-wise within a business day, and that's I give myself 48 hours in my agreement, but I try to do it within a business day. But there are clients that are just unreasonable. There are clients that will email you at 9 a.m. and 10 a.m. and 11 a.m. if you haven't responded yet. I mean, everybody knows that there are clients like that out there, and sometimes I will just say to somebody who does that, call me, because often what happens is when they call, you can talk to them about the situation, as opposed to creating a 13 email chain about this problem. You have a 3-minute or a 5-minute telephone call about going back to, this is when you can expect responses from me. I will answer you. I will get back to this, but I don't need to see it in my inbox 5 times before I get back to it, or something to that extent. So I often respond to these people by telling them to call me. Almost always I have that conversation with them over the telephone to remind them and to go back to the rules. And there are some people who are very rude about it, and you have to address that too. I don't give my cell phone out to clients, but for a very select few. I'm very restricted as to who gets that number and why. I don't take any text messages from any of my clients. They tried to text the office phone, and it wouldn't work, so I have no way of getting that. So it really comes down to I think setting that up in your initial meeting. My initial meeting with clients is particularly long. I mean, I'm usually with clients in that initial meeting at least an hour, because I'm going over a lot of these nuts and bolts, and if they're not in agreement with the nuts and bolts, then that's not a client that's going to be a client of mine.
Anybody else?
I think the call is a very good idea. I wonder, just listen to people, since you can't identify necessarily the clients who are going to be difficult. Do you treat everybody the same, or some people that you say, well, I really don't need to go into it that way, it might be off-putting? Do you make judgments like that?
Usually not. Usually I go over it with just about everybody, apart from people that, are giving me a new matter that I've already dealt with before, or something like that. But most business clients, of course, have the same business hours that I do, so it isn't usually that big of an ordeal with them. It's usually the clients that may be on the, individual side that I have to every once in a while remind, or when we're sitting down in that conversation. I tend to be very common sense with it. I don't try to put it in a way that's over their head or make them feel belittled in any way. I just say, this is how my office operates. Do you think that this works for your needs for this case? You bring it more on the level of their expectations as to what they're looking for. Here's what I can deliver. Do you think this will work? And if they say, no, my expectation is you'll get back to me by the end of every business day for every email, even if it's 17 of them, at least I know that right off the bat. And of course, clients can be dishonest and not tell me that that's not their expectation, but I can go back and say, remember when we had this discussion about what I could perform for you, and you agreed that that was what you were looking for, and we came to that mutual agreement on this. Most of the time, they'll remember that conversation. They won't like that they remember that conversation, but they will, and most of the time it works out. And over the telephone is much better than an email chain. You can accomplish so much more.
You just can't do it at 3 a.m.
Right, yes, yes.
Well, we've reached our time for the second session. I am happy to extend it a few minutes. If there are any other questions, comments, this is your last opportunity.
I have a couple of final thoughts that I would like to leave people with.
I was going to get to you, Ira,
Okay.
and thank you for coming from Oregon. Ira has a reunion for UW coming up, and I know you enjoy, it's a football weekend, and I know you tell us why you enjoy coming for football now as opposed to when you were...
Well, when I was here in my last 2 years of undergraduate, Wisconsin was 0-19-1. And I believe the one was a 3-3 tie with Northwestern in a driving rainstorm. But
You were there probably.
Well, I mixed up the 3-3 ties, so I don't know. But it was, so that wasn't good. So I'm glad to go back. But now I'm in Oregon, and they have a great football team. But, and I've been there a long time, so. But my final thoughts are is that even though the world really has changed and the way people practice law has changed, like I say, discovery has changed and how all that, depositions, all that stuff has changed, that the same ethical rules apply, and you need to keep that in mind. And that, so when you communicate with people, obviously one of the real caveats is write only what's true, don't misrepresent anybody. When you are investigating something with social media, don't use any subterfuge to investigate it. Make sure you're not communicating with someone who's represented, and that's something that happens pretty regularly if you're not careful. Don't write about or communicate with your clients about legal matters on social networking sites at all. Just don't do that. Caution clients to refrain from commenting on their legal cases in social media. It's another sort of danger point if you're a litigator, certainly. Don't communicate with persons who are off limits, which is the representative people. Avoid creating inadvertent client relationships, which is what you promise when you're going to tweet or whether you're going to be one of these services. You really need to know what you're offering and have disclaimers. I think those disclaimers are ethically required for you if you're going to invite someone to send you something, that they need to know that it won't be confidential and it's not creating a relationship. Never, ever give legal advice online. It's just too hard to do it accurately and in depth. And also, I think everybody should develop a social media policy for their firm and everybody in it so that everybody follows the same rules. So those are my takeaways from
Very
all
good.
this.
Any other final thoughts, panelists?
Recently, you maybe know more about this than I do, so please jump in. There was a call in our office from a lawyer who had an associate who had liked something on Facebook. Unfortunately, the associate did not know that the firm, it dealt with a legal matter, and didn't know that the firm was in fact representing one of the parties involved in this matter. This is so fraught with danger. You know, what you do even on your own personal media, social media sites, and what you like and don't like, it can come back to.
How did the firm find out about it?
The client figured it out.
They were looking at the Facebook
They were
of the
looking at the
associate?
Facebook of the associate.
I think my comments are two. One, the thing that stuck out the most for me that was said in the beginning of the day was, amidst all these changes, the ethical rules have not changed. They're still there. So you have to figure out how to wrap your head around all that and still comply with the rules. The social media stuff, I think Ira's point about the firm having a policy of how you do it or what lawyers within the firm should be doing is well taken. I think that's a great tip for people. I can tell a similar story. I know a young lawyer who went and competed in a triathlon, and something happened at that triathlon. He was pretty critical of it, and he sent the director of the triathlon an email about the incident that took place in the triathlon. Well, lo and behold, on Tuesday morning, the managing partner of the firm went and talked to that lawyer and said, "Do you know that they're a client of ours?" So here you've got a lawyer in the firm criticizing a client. So it does have a ripple effect, all of the social media stuff, and I think creating a policy is a great idea and it's a great tip.
All right.
You can skip me.
Anybody else? Okay. Before I let you go, I want to throw out some thank yous. Thank you to Dennis and Brian for handling the video. Thank you to Katya for handling the web traffic and getting us that information and the questions. Thanks to all of you who came to participate in this. We really appreciate you doing that. And to the web people who watched us today. And I want to thank our great panelists, Jeff Smith from Madison, Ira Zara from Oregon, Joe and Sally from WILMIC, and Shannon Winn from Lake Geneva. Thank you all very much. You've been great. So thanks again. If you have any other questions you want to talk to these folks afterwards, feel free to do so. And thanks again.